We're now going to move to item 82, to conduct a public forum in accordance with Government Code Section 7283-1, subdivision, and receive a report from the Sheriff Coroner's Administrator's Department. We're going to ask for the presentation from the Sheriff. Good morning. Well, actually, good afternoon.
Good afternoon, Supervisor. This presentation will be as a result of the Truth Act, which was passed in 2017, but I want to give a bit of history of the laws that have changed in regards to immigration and our correctional facilities over the last number of years. Beginning with AB 4, which was the Trust Act, which prevented law enforcement from keeping individuals in custody at the request of ICE past their normal release time, which historically was done. Prior to this, we kept them for 48 hours so ICE could pick up those inmates that they were interested in. AB 4 prevented that from occurring. Then in 2017, January 2017, was the Truth Act, which described basically a process by which ICE would come in and speak to an inmate that was in our custody that they were interested in. We would have to provide that inmate with a form indicating that ICE had an interest in talking to them and that their interview with the ICE official was voluntary. And in addition, provide them with documentation that ICE was interested in knowing their release date. And then in January of 18 was SB 54, which is also referred to as the Values Act, which limited our ability to communicate with ICE unless the inmate in our custody met certain criteria.
Good afternoon. I'm Tracy Reese, Assistant Chief of the Probation Department, to give a brief report on the probation process. So pursuant to SB 54, the Probation Department does not inquire into an individual's immigration status, that would be for the purpose of immigration enforcement, detain a person based on a hold request from ICE, participate in 287G agreements or any program that deputizes a police officer as an immigration agent, participate in border patrol activities, including warrantless searches, use immigration agents as interpreters, participate in task force operations when immigration enforcement is the primary purpose of the task force, initiate contact with ICE to advise them of an individual's detention or immigration status. The department's protocol is that probation officers will comply and cooperate when there is an active federal warrant for deportation. That would be a judicial warrant already signed by a judge.
The interactions between ICE and our department, and let me back up for a second, and the purpose of this report is to talk about the actions that our department was involved with ICE in 2017, prior to SB 54, specifically about the Truth Act. Our department may allow ICE to conduct investigations inside of our facilities as long as they don't violate any federal, state, or local laws. They primarily conduct immigration enforcement by identifying in-custody inmates through fingerprints. Every inmate that's arrested and booked in our facilities is fingerprinted. Those prints are sent electronically to a variety of different places, including Homeland Security, FBI, and others, to determine if that individual is wanted for a variety of different reasons. Federal, state, and local laws permit ICE to identify and detain undocumented individuals who pose a threat to public safety. Consistent with probation, we do not enforce federal laws or participate in immigration programs. We do not ask an inmate's immigration status for the purpose of immigration enforcement. And we do not use ICE personnel as interpreters within our jail facilities. Those that are housed in our facilities are not categorized, classified, or housed based on their immigration status. Their access to educational programs and credit earning opportunities have no bearing on their immigration status. ICE can interview inmates that are in our custody as any other law enforcement agency would do. But prior to that interview, back to the Truth Act or the Trust Act, prior to any interview, an inmate must be informed of the purpose of the voluntary interview, the right to decline that interview should they choose, and the right to have an attorney present during an interview. They receive those rights in writing for the consent and immigration and customs interview form. It's this one here. This form is provided to the inmate that suggests that ICE wants to interview that person, gives them their rights, they sign that form, and they're provided with a copy of it. And ICE does not have dedicated workspace inside of any of our facilities.
Why?
They can enter our facilities, they can go into the secure part of our facilities, they can access the bridge, they can access the intake area, all of that, but they do not have dedicated workspace because that's prohibited in SB 54.
Why?
ICE holds and detainers. There's two separate forms that ICE provides us. One, a detention form, which asks us to detain that inmate past their release time. SB 54, as of January of 18, prevents that, but so does a variety of other reasons, court decisions at the federal level, and a variety of other things that do not allow any law enforcement agency to keep that inmate past their county release time. So we do not comply with the detainer form and keep that inmate past their county release time. So we do not hold them any longer than their regularly scheduled release. We will notify an inmate that ICE is interested in that person, and depending on, now in 18, based on SB 54, if we're going to provide the release information to ICE, we will do so and notify that inmate, and the attached form will be prepared and provided to that inmate as well. ICE notifications and transfers, that's the second form they provide us. It's a 247N form. That requests us to notify ICE at the time of that inmate's release from our custody. We can provide release date information if the information is available to the public and the inmate meets the release information requirements. All of our release dates that are known are published on our website. There are inmates in our custody that may be there for a short period of time, as an example for a DUI, that is going to be site released and we don't know their exact release date and or time. Those inmates that are sentenced, their release date is known, unless something happens while they're in custody and they lose some of their credits, and that date gets adjusted. But for those inmates that we know their release date, we enter that information on the website and it's available to the public. As is any other information about an inmate's age, name, current charges, bail amount, when their next court date is. Any of that information that's public is on the website. But ICE chooses to call our facility and asks if an inmate is in custody. We will provide that information just as we would anybody else. If they ask for that inmate's release date, we will provide that information as we would with anybody else. When we notify ICE of the inmate's release date, we provide that information to the inmate as well. We use this form that notifies them that we shared the information with ICE and that at the time of the inmate's release, we will notify them. We can only transfer an inmate to ICE custody if the inmate has a valid warrant signed by a judge or a certification of probable cause signed by a magistrate as well. But we can provide non-public release information to ICE when the inmate meets the criteria under SB 54. Now, what we're talking about today was what was occurring in 2017. We could provide ICE, in essence, unlimited information in 2017 because SB 54 was not law at that point in time. So in 2017, if ICE asked us to notify, we could notify on any offense that the inmate was in custody for. We could let ICE know at the time they were walking out the door that that inmate was being released, or before if we knew it. SB 54 prevents us from doing that. So this is kind of a combination of what we do today and what we did in 2017. What we do today, the inmate has to meet the criteria of SB 54 before we can call ICE and let them know that this inmate is being released. Once the inmate is released, ICE can meet that inmate in the lobby and take custody should they choose. If we choose to notify ICE because that inmate meets the criteria, There's two worksheets, one of which you see here, and the second one here, that our staff completes to make sure that they comply with SB 54. If the criteria is met for SB 54, then we will notify ICE when the inmate's being released. But again, that's not primarily what we're talking about today. This is what is occurring after January of 2018. ICE arrest and transfer. ICE personnel are solely responsible for making the immigration-related arrests at our facility. There's no designated area for them to arrest inmates scheduled for release. ICE arrest must occur in an area accessible to the public according to SB 54. We will not directly transfer inmates to ICE unless the arrest warrant is present and signed by the judge. Some rough statistics from 2017, and this is just for those requests that we received at West Valley in 2017. Total jail bookings were over 82,000. Total releases were over 87,000. ICE requests that we received at West Valley in 2017, just at West Valley, are about 570. And ICE pickups at West Valley were about 353. Now there's the opportunity or the chance that there were more ICE requests sent to our facilities throughout the county in 2017. And those estimates on the number of inmates that were actually picked up can vary. We don't know necessarily how many folks that they arrested in the lobby and took custody of, because we don't track that. It occurs in the public lobby of our facilities. That still occurs today, so the number of folks that ICE actually takes custody of is based on information that ICE provides. We don't have accurate information as it relates to that. Summarize. Inmates that are lawfully booked inside of our facilities are fingerprinted. Those fingerprints are sent to a variety of places, including Homeland Security. That's what triggers the potential ICE request for notification and/or detention. We don't notify ICE of somebody that's in our custody that is potentially undocumented because we don't have that information. We don't have access to the federal computers to run people's names to see if they're in the country with documents or not. That is all based solely on the fingerprints that are transmitted electronically to ICE. They make that decision. Their requests for notification are their decisions. We log those when we receive them and ultimately make the decision under SB 54 whether we can or we can't notify ICE at the time of release. But if ICE calls us and asks us if we have an inmate in custody and gives us the name, we have to say yes or no, because that's public to anybody. And if they ask us when that inmate will be released, we're required to tell them if we know the date and time that that inmate is going to be released. Happy to answer any questions.
Any questions? Not at this time, we have any. Thank you both for your presentation. Deputy Chair.
Thank you.